Good evening, Assalamu alaikum. I think Law Makan has become India International Center of Hyderabad. When I came here for the first time, it was a book release of my young friend Hilal, Siyasi Musalman. I think let me first of all pay my tributes to Moeed Hassan Bhai, who was 3-in-1, scientist, photographer and lover of art, and somebody committed to liberal arts and worried about what is happening in the world. I am really grateful to the organizers for inviting me for their most prestigious event. Several eminent personalities, as you heard, had already spoken from this podium. I'm sorry and really sorry for a change of date due to developments in my life. I had to move from Aligarh to CNLU, and unlike several other vice chancellors who are visiting vice chancellors in the sense sometimes they visit their universities as well, I'm not that great a vice chancellor and that great an administrator, and therefore unlike them I don't have the abilities to run university remotely, so I had to be there at least in the first 3 weeks. We picked up the topic of UCC because the Prime Minister in a recent speech in Bhopal made a very strong case for UCC. And then Law Commission of India invited opinion of people of India in less than 5 years. They had done a similar exercise 5 years ago, and they have concluded that UCC is neither feasible nor desirable. And then just about a few weeks back, I think 3 weeks back, the Parliamentary Standing Committee on Law and Justice said that tribals be excluded from UCC. So the so-called and much hyped UCC will not really be uniform. And then just 2 days ago, I'm just telling you the context in which this topic has been picked up. The Honorable President of our Republic appreciated Goa Civil Code. 2 years ago, the Chief Justice of India had said that Goa is the shining example of a uniform civil code. I had to write a rebuttal in Indian Express to say that neither it is uniform and nor it is a shining example of uniform civil code. It does permit limited polygamy, and it is not absolutely gender just. What is my position? I have spoken and written in last so many decades on uniform civil code, and I have been consistent that I am for uniform civil code. But when I said it recently, many friends in Aligarh said that I have joined the Hindutva brigade. And my case has become like that, Zahide tang nazar ne mujhe kafir jana, aur kafir ye samajhta hai ki Musalman hu main. My problem is that I am a constitutional law teacher who is wedded, in addition to Dr. Era, to constitutional values and mandate. And therefore, I favor secularism and freedom of religion because Constitution talks of liberty of thought, belief, faith, and worship. I spoke without fear on CAA because as a matter of principle, Constitution opposes religious test of citizenship and favors citizenship by birth, though the Citizenship Act diluted this liberal idea of citizenship by birth, first in 1987 and then in 2003 and then recently. I also spoke and wrote on 370, again because of a constitutional principle of federalism, which Supreme Court said is the basic structure of the Constitution. So somebody who is so deeply wedded to the constitutional ideals cannot say that uniform civil code, though in constitution, but I oppose it. So I cannot oppose it like that. I say it is in the constitution, and therefore I am for uniform civil code. And therefore I am for what Article 14 says, that state shall make endeavor to have a uniform civil code. The problem is that there has hardly been any endeavor, other than some speeches here and there. And more of these speeches, very interestingly, had come, or such statements in favor of uniform civil code had come not from the political class, but from our judges, to which I will make a reference. Judgment after judgments, many times the matter was not before them. This is called obiter dicta, when a judge makes a passing reference. The dispute is something else, but he says something else. So I favor making of endeavor, and the endeavor has not been there because there is no draft as of now. And no, since it is said, and I'll give details of Muslim personal law, because that is where the shoe pinches right now, because most of other laws have been reformed. Unlike Hindu Law Reform Committee, which was formed in 1941 and which led to Hindu Code Bill in 1955, it took some 15 years, and it led to such a kind of debate that when Ambedkar introduced initially the uniform civil, the Hindu Code Bill, out of some 27 speakers who spoke, 25 of them opposed Hindu Code Bill. The President of the Republic, Rajendra Prasad, said, I will not sign it if it is passed by the Parliament. People said on the floor of the House that Ambedkar is taking a revenge from the caste Hindus, he being a Shudra. There were protests organized. In 1949, as many as 74 protests against the Hindu Code Bill were organized in Delhi alone. Ambedkar had to resign as a law minister. The code had to be diluted, and it is to be passed after few years, not as one code. So we could not give one code, one uniform code even to Hindus. And there is no uniform law, as I'm going to tell you in few minutes, even for Hindus, what to say for the entire country. So my position is very simple. Form a committee like the Hindu Law Reform Committee of experts for Muslim law. Let them first deliberate and come up with a report that what are the areas that require reform and how those reforms are to be really undertaken. So take the baby steps towards uniform civil code, and I have repeatedly said that I am for a piecemeal reform. Reform something today and another thing tomorrow and a third thing day after, rather than doing it in one go. If it is going to polarize our society, if it is going to allow hijacking of this debate by the fundamentalists on both sides now. Earlier only one side fundamentalists were against uniform civil code. So don't allow hijacking of debate. I had therefore favored and welcomed when Uttarakhand Chief Minister took the initiative on the last day of the election campaign, and I had said that law reform has nothing to do with elections, and therefore law reform and electoral battles should be delinked. Nevertheless, when he formed the committee, I was disappointed, and I had to write, the committee does not have any expert of personal law. And if a committee like this gives a report, it will not inspire the confidence. I am equally frustrated with the Muslim Personal Law Board, which has not taken any serious step towards this constitutional mandate. I think Muslim ulama and the Personal Law Board must acknowledge and recognize that in modern liberal democracies, the supreme law of the land will be the constitution, will not be and cannot be any religious law. And therefore, all religious laws and all secular laws have to be compatible and consistent with the constitution. Any law which is contrary to constitution or any practice which is contrary to constitution has to make way. And therefore, reforms are to be done. The internal reform should have been done. I have said it many times in personal discussions that one day Uniform Civil Code will definitely be enacted. Be ready with a draft. When the government is going to enact a Uniform Civil Code, personal law board should be able to give them a draft. This is our wish list. This is what we want to be incorporated. Today, I feel sad to say that we don't have even one section drafted which we can tell to the government include it. At the same time, I am conscious of the fact that reforming any law is difficult. I mean, the religious law is far more difficult. When untouchables were to be allowed an entry in the Hindu temples, the story goes like this, that there was a Pune Pact, as you know, between Gandhiji and Ambedkar, but Gandhiji did not sign it. It was signed on Gandhiji's behalf by Madan Mohan Malviya, who was a representative of Hindu Mahasabha as well as of Congress and a representative of caste Hindus. And Gandhiji, as you know, was on a fast. After the signing of the Pune Pact, by which the untouchables were to give up their right to separate electorate, and they were given a large number of reserved seats, Gandhiji did not break the fast. And he said, there are two more conditions. Then only I will break the fast. First, that the British government should accept Pune Pact. And two, the caste Hindus must take a vow that they will take all initiatives to ensure entry of untouchables in the temples and in the secular places. And therefore, such a public oath was taken on 25th of September 1932, and Malviya ji was leading it under pressure from Gandhi. And then on 30th September, just after 4 days, another meeting was held where it was diluted. And it was said, you know, don't take any coercive measure, just persuade people and do it. This was, of course, Gandhiji's also earlier position that a referendum should be done in the vicinity of a Hindu temple, and if the majority of Hindus are agreeable, then only the Shudras or the Dalits should enter the Hindu temple. So there has been quite a debate on this, and ultimately it led to some kind of differences of opinion between Malviya and Gandhi. When Gandhiji asked Malviya to come and meet him in Pune jail, he did not go. And then he wrote a letter that your position that the Shastras don't talk of, untouchables, and don't talk of, some people being cause of pollution, you are wrong. And what Malviya was basically opposing was a law, a legislation which will permit the, SCs to enter the Hindu temples. And similar thing happened when this Protection of Civil Rights Act was passed in 1955. It is Nehru government, it is Kardju as Home Minister who is introducing the bill, and the introducer of the bill is saying this bill is bad. This bill should not be passed. There was just a punishment of 6 months or fine, And he was saying, no, there should not be punishment. Punishment should be very light. People who will go to jail, when they return from the jail, they will not have any affection for the Shudras, and therefore the bill is bad. And then Ambedkar had to, by that time he had become an opposition leader, stand up in Rajya Sabha and say that all this is nonsense. And he said that the bill is bad because there is no minimum punishment, and if some Pandit from Kashi becomes a magistrate, he will just say 1 day out of 6 months, because maximum is 6 months. He can also give 1 day imprisonment or maybe 1 rupee fine. So reforming religious laws is quite a task, and it is not easy. About Muslim law, I am fond of referring to one of the greatest, all-time greatest writer on family laws, basically an expert of Hindu law, Duncan Derrett. And this is what he said, and I quote, "The best way to reform Mohammedan law is not to reform it at all. Let its inconvenient and archaic features wither away. Once it is accepted that that is the policy, it will wither away fast. If there is a frontal attack on personal law, it will survive with the tenacity it has been unable to show in countries where the majority of population are and always have been Muslims." Unquote. If you do not make too much of an argument about Muslim law reform, then it will wither away. It will wither away fast, the way it has to some extent or great extent withered away in the Muslim countries. Now the topic says, why uniform civil code and why not? So let me first address why broadly, and then answering this why, I will talk of why not. Argument is made that UCC will promote national unity and integration. That was a context in which even in the Constituent Assembly debates, a reference was made to Uniform Civil Code, and not in the context of gender justice. Argument is made that equality, gender justice, and non-discriminatory laws are the constitutional goals, and UCC is a means to that end. And that is my problem. Somebody who teaches constitutional law, who believes in these goals of equality and gender justice and non-discriminatory, non-oppressive laws, I cannot say that don't have a code which will provide all this. Then it is also said by those who favor Uniform Civil Code, who say why Uniform Civil Code, that, well, freedom of religion is not absolute. And they are right. No freedom is absolute. No right can be absolute. In fact, if you look at freedom of religion provision of the Constitution, it starts with restrictions. It says subject to public order, health, morality, and other provisions of this part, which means other fundamental rights, you will have freedom of religion. Therefore, if there is a conflict between right to equality and freedom of religion has to make way for right to equality. Between the two, right to equality would prevail. If there is a conflict between freedom of speech and religion, then freedom of speech shall prevail. And that's why I have always argued that blasphemy should no more be a criminal offense. And it is depressing to note that the new Bharatiya Nihaya Sanghita, so to say, does include a provision on blasphemy, and that's why it's not a very, very progressive law. Now, moreover, freedom of religion does not mean that you will do each and everything which your religion permits you to do or mandates you to do. Our law, of course, I am not very comfortable with this law, and I have been writing against Supreme Court that Supreme Court should not become clergy. what is essential and what is non-essential feature of a religion is purely a theological question. And the judges are trained in common law. They are not trained in dharmashastras. They are not trained in scriptures. And therefore, this is not their field of expertise that they tell us what is essential and what is not essential in any religion. They quoted me in Sabrimala and they said that Professor Mustafa doesn't agree with this position. We find it important to mention, but still they went ahead. But subsequently after Sabrimala, as all of you know, since the government was not very keen on that progressive judgment, a review was accepted. And in acceptance of review also, we violated the settled law. The settled law is that a review of Supreme Court judgment can be accepted only when an error apparent on record in the judgment is pointed out. No error was pointed out. But government also wanted Sabrimala in a way to be overturned. And that's why 7-judge bench was constituted and 7 questions were framed. And had that bench decided it, the essential practices test would have been overruled. But in the review bench, Chandrachud was there as a dissenting judge along with Nariman, who said it should not be reviewed. So I don't see review of Sabrimala coming up for next year and a half while Chandrachud is at the helm of affairs. But just testing this argument little bit, if we want to say that freedom of religion guarantees us right to follow our religion, the law today is that you can follow in the name of freedom of religion only something which is the essential feature of your religion. And how do you decide something is an essential feature of your religion? If it will destroy the religion. If it is not permitted, then you won't be able to recognize that religion in that form. Can any Muslim stand up and say, unless I have 4 wives, I will not be a Muslim and Islam will not be recognizable as a religion? No. Or can any Muslim really say that unless I give 3 divorces in one go, Islam will not be recognizable as a religion? You can't say that, because even in Shairabano, even the personal law board has said that giving of triple divorce is a sin. And that is exactly what Justice Joseph said when I confronted him after this judgment. He said, Professor Mustafa, what can I do? You are in a religious law. I am a believing Christian. Something which you say on oath is sinful, and then you want me to enforce. I will not enforce in a religious law. Because in religious law, law and morality are very closely linked. And therefore, I don't think this argument of freedom of religion can really take us forward. It is also said in favor of uniform civil code. So many Muslim countries have reformed Islamic law. Why Indian Muslims are resisting it? I would like to answer it straight away here so that we get more time for questions. Reforming majority communities' law is easier than reforming the minority communities' law because of the minority psyche. Muslim countries were able to reform Muslim law because Muslims were in majority. Hindu law reform was undertaken by Nehru because Hindus were in majority. In Pakistan, they reformed Muslim law, but they did not reform Hindu law. The other reason is that we should also look at how Muslim countries reformed their laws. To reform a law, you need to find a juristic opinion. Because all personal laws, I'm going to speak little at length on this, the opposition to any change in personal law comes because we think personal law is sacred and personal law is divine. Is entire Muslim personal law totally 100% divine given in Quran? Then of course the opposition will be justified. But if it is a juristic law, a jurist given law, Muslim law or Hindu law, like Roman law, is jurist given law. Manu was not God. He was a jurist. Imam Abu Hanifa or Imam Shafi'i or Imam Malik were neither God nor prophet. They were human beings who were experts of law. And therefore their opinions cannot be said to be sacred at the same level as is Quran or the Sunnah of the Prophet ﷺ. So, are we doing in India, and that is a job which Personal Law Board ideally should have done, to look at juristic justification of reform? How do we reform? We find a jurist who gives a liberal interpretation and take that opinion in preference to conservative or orthodox opinion of some other jurist. And I'm going to tell you that our ulama did do it in 1939. What they did in 1939, why they can't do today, I'm unable to understand. Then it is said that Hindus have reformed their personal laws, and since they had it, you should also have it. That's not a great way of putting things, but entire Hindu law has not been yet reformed. Even today, after 75 years of our independence, if there is a Hindu couple, a childless Hindu couple, if the husband dies, all his property will go to his parents. If the daughter-in-law dies, all her property will also go to father-in-law and mother-in-law, and not to her father and her mother. When we made Hindu Succession Act, we could not provide a right to ancestral property. We could not make daughter as a co-parsoner. Wife is not a co-parsoner even today. And we should also see whether the law reform has really paid off. Because what did we do? Looking deeper into the Hindu law reform, if that is a recipe, then we should say whether this medicine has worked well. If it has not worked well, then we should not experiment. We should rather learn from others' experiment. As khud tajarbe mat kijiye. We said that in the self-acquired property in 1955, daughter and son will get an equal share in the property. In the property of a Hindu, whatever property he acquired, if he is a professor or an IAS officer, not his Dade Ilahi property, not his ancestral property, which will go to the Hindu joint family, where daughter was not even an heir until 2005. In the father's self-acquired property, daughter and son will equally inherit. And we said, look, Muslim law is so bad. Daughters get half a share, and therefore it must be reformed. Simultaneously, we gave a right to the father to will away his entire property to whomsoever he wants. And as a result, most of the fathers, what they do? कन्यादान तुम्हारा हो गया, जो कुछ देना था दे दिया जहेज में, ज्वेलरी वगैरह. Now no share in property. Entire property they give through will to the sons. And that is reflected in the ownership. After 70 years, look at how many Hindu women own what quantity of property. They should own the same quantity of property which their brothers or the Hindu male are owning. But that is not a case. The difference is of maybe 1/10, 1/20. And in any case, we must also understand we are a patriarchal society. even where property is registered in the name of a woman, because you have to pay less registration fee or registry fee, does she control the property? No, the papers will be with me. I will sell whenever I want. She can't sell. And that's why we need to understand what Duncan Derrett is saying. It's not easy when religion is involved to reform laws. It is also said, and as another argument, oh, Muslims have abandoned Islamic criminal law, Islamic commercial law, Islamic constitutional law. Why they resist similar uniformity under UCC? The brief answer is, criminal law is an instrument of a state. Marriage is not an instrument of a state. Whom one marries is a personal matter. And therefore, state took the initiative. If tomorrow state passes uniform civil code, Muslims can do nothing about it. So why state has not passed it? But the real reason is this, that there is a continuity with the Mughal Empire. Mughals as a policy did not interfere with the religious laws of Hindus. And when British came in, they continued this policy. Don't interfere in religious matters. And that's how this whole idea of personal law was born. Let me now respond to the question, why not uniform civil code? And you now know that I am a votary of a reform, and I am also for UCC in piecemeal. But let us look more closely on the question of a Muslim personal law and Muslim resistance to reform, and look at the root problem of resistance to reform. I personally believe that personal law and Sharia are two distinct words. Generations of Indian Muslims have confused them and taken them as synonymous. Sharia and Muslim personal law are not one and same. And why I am saying so? Because the word for law is fiqh, not Sharia. So what is the difference between fiqh and Sharia? Sharia governs the relationship between man and God. So believe in oneness of God, believe in angels of God, believe in day of judgment, believe in la makan. That is Sharia. But how do you marry? Whom do you marry? How do you divorce? How your property is divided? How you make a gift? How you make a will? This happens between human beings. And therefore, while Sharia has a closer affinity with divinity, fiqh or law has a closer affinity with human beings. And you will be surprised. There is no equal word for law in Sanskrit. Dharma is neither law nor religion. It's an idea which is much broader than what we understand as law in modern Western sense. The idea of righteousness. So Quran, which is the foremost source of law for Muslims, how much law it tells us? Just about 400, 500 verses out of 7,000. So I believe that Allah subhanahu wa ta'ala in His wisdom decided not to give us law as a finished product. You are going to marry, you are going to divorce, you evolve your law. He is not giving us law, this section, that section. And that is the whole problem of Muslim personal law in India, that our judges interpret Quran as if they are interpreting Constitution of India or Indian Contract Act or Indian Penal Code. It is not an enacted law. Quran is a book of guidance. It's a source of law, not law in itself. Law is to be extracted from Quran and Sunnah and other sources. So it seems to be the scheme of Allah subhanahu wa ta'ala that you discover your law through juristic enterprise. Fuqaha will tell you the law. Jurist intervenes between God and human beings. This was also influence of Roman law on Islam, because Arabs had trade relations with Romans. And as a result, jurists give us law. They interpret sources. The difference between British law or the Indian law under the influence of British common law and Islamic law is this. In British law or Indian law, law is made first and interpretation comes from judges afterwards. Parliament will first make a law, then judges will interpret. Under Islamic law, interpretation comes first. And law is not interpreted. Sources are interpreted. So Quran and Sunnah and Qiyas and Ijma, they will be interpreted. So jurists would interpret Quran and Sunnah, Ijma and Qiyas, public interest, urf or customs, juristic preference, and all this except Quran and Sunnah are divine. Prophet was, of course, as per Muslim belief, was divinely inspired. So when you look at Muslim personal law, it is not entirely divine, because entire Muslim personal law is neither in Quran nor in Sunnah. What is your personal law? It contains laws made by Britishers, laws made by Indian Parliament, laws made by several state assemblies, regulations made by Warren Hastings. They are part of your Muslim personal law. And that is why the correct name for your law in India is not either Islamic law or Muslim law, but Anglo-Mohammedan law. Anglo. This is British creation. What you call Muslim personal law is gift of Britishers. Just to give you an example, Warren Hastings came up with regulations 2 of 1772. And he said that if there is a dispute between two Muslims, then law of Quran, and Hindus, then law of Dharma Shastras will apply. This was a rule of Muslim personal law. There was an act, Awadh Act of 1876, which said court can reduce dower. अवध में ऐसी लड़कियां रही होंगी जो बहुत ज़्यादा डावर फिक्स कराती होंगी, तो कोर्ट को ये पावर दी गई कि भाई अगर उन्होंने 50 करोड़ डावर फिक्स करा लिया है तो कोर्ट रिड्यूस कर देगी. इन बंगाल यू हैड बंगाल मोहम्मदन मैरिजेस एंड डिवोर्स रजिस्ट्रेशन एक्ट 1876. मैरिज भी रजिस्टर होगी, डिवोर्स भी रजिस्टर होगी. ये पर्सनल लॉ है, आपका लॉ है. ये कहाँ लिखा है कुरान में कि रजिस्टर करो मैरिज? आसाम मुस्लिम मैरिज एंड डिवोर्स रजिस्ट्रेशन एक्ट 1935. बंगाल में मैंडेटरी था, यहाँ वॉलंटरी था. उन्होंने कहा भाई रजिस्टर करा लो तो बेहतर है. काजीज एक्ट 1864, सारी जुडिशियल पावर्स ऑफ काजीज वर विथड्रॉन. जम्मू कश्मीर यू हैड जम्मू एंड कश्मीर मुस्लिम डावर एक्ट ऑफ 1920. 1918 मोपिला सक्सेशन एक्ट. मोपिला Muslims were following local inheritance law. Now they wanted that their property should not go to sisters' children, but to their own children. Therefore, they said we want to follow Muslim personal law. And therefore, this law was passed and it has become part of Muslim personal law. Malabar Wills Act of 1898. Under Sunni Muslim law, you cannot make will of your entire property. You can make will of only 1/3 of your property. Now these people wanted the Hindu law. Abhi Hindu Act nahi bana tha, but Hindu law. And therefore they said unlimited testamentary power. Similarly, you had a Kachi-Memon Act of 1920 and Kachi-Memon Act of 1938. You had a Shariat Act of 1937. Why was Shariat Act passed? Because Muslims were not giving, particularly in northwest frontier, which is today's Pakistan and Punjab, any property to daughters. They were following the Hindu customs. Daughters are not entitled to any inheritance. And therefore, to give that right to Muslim daughters, Shariat Act was passed. But there was a catch. In the Shariat Act, they said it would exclude agricultural property. Islam does not make a distinction between urban property and agricultural property. But Shariat Act says that Muslim Personal Law, Shariat Application Act will not apply to landed property. मुसलमान जमींदार थे, जमींदार अपनी जमींदारियां नहीं देना चाहते थे बेटियों, तो वो exclude हो गया. Of course, there was another reason also, because it was a central law and agriculture was provincial subject. Then you got dissolution of Muslim Marriage Act 1939. Very interesting reason for this law. Even though Islam gives Muslim daughters, Muslim women right to divorce, but हमारे उलेमा उनको खुला तक देने को राजी नहीं थे. As a result, Muslim women had no option. If their marriage has failed, the only option available to them was to convert. Islam छोड़ेंगी तो marriage automatically dissolve हो जाएगी. So large number of Muslim women started converting to dissolve marriage. अब हमारे उलेमा भागे हुए अंग्रेज़ों के पास गए. उन्होंने कहा भाई ऐसा करिए कि ये कन्वर्जन के बाद मैरिज डिसॉल्व ना हो. बिल्कुल शरिया के खिलाफ है, ये बिल्कुल इस्लामिक फिक़्ह के खिलाफ है जो इनकी डिमांड थी. एंड द ब्रिटिश गवर्नमेंट नेचुरली सेड देन यू मेक अ वे, एंड दैट्स हाउ अ राइट टू डिवोर्स वाज गारंटीड टू देम. And Muslim women are getting a right to divorce in 1939. Hindu women will get in 1955. And even today, 1939 law is far more liberal than the 1955 law. So you have so many laws. These are all personal laws. Then you had several judgments. Judgments of the British court, judgments of the Indian court. Shah Bano has become a part of Muslim personal law. Shaira Bano has become a part of Muslim personal law. So what is left of Muslim personal law after legislation and after judgments, the uncodified part is a very small part. And the fight is to retain that small part. Now that takes me to how Muslim law was developed. And you would be surprised that it took several centuries to develop after Prophet sallallahu alaihi wasallam. Some 300 years were taken to develop. भाई दीन तो मुकम्मल हो चुका था, अकमल तो लकुम दीनकुम पे. अब तो लॉ बन रहा है, दीन नहीं बन रहा है. दीन तो हो गया वहां, उस खुतबा हज में हो गया खत्म दीन. Even Mughal emperors did not implement Sharia in totality. I am picking up example from Aurangzeb because he is considered to be the most conservative one. And he is the one who had got large number of ulama to sit together and to come up with a compendium of laws, what is said to be Fatwa-e-Alamgiri. So Fatwa-e-Alamgiri ke against Emperor Aurangzeb went, and he issued an edict, a decree on 16th June 1672 to the Diwan of Gujarat, suggesting the infliction of imprisonment instead of amputation चोरी अगर कोई करे तो हाथ मत काटो, उसे जेल में रखो। अब ये तो बिल्कुल आप मुस्लिम स्टेट है और औरंगजेब एम्परर हैं और फतवा आलमगीरी है, और वो कह रहे हैं कि नहीं, इसमें आप जो हैं वो इम्प्रिजनमेंट दें। सिमिलरली इन 1690 अ फरमान वॉज इशूड बाय औरंगजेब। ये आज का झगड़ा चल रहा है अभी कि अगर किसी का बाप मर गया और चचा मौजूद है तो दादा की प्रॉपर्टी में जिसका बाप मर गया उसको प्रॉपर्टी नहीं मिलती। औरंगजेब का फरमान है ये, प्रोवाइडिंग के इनहेरिटेंस दे दिया जाए टू दैट ग्रैंड सन, द प्रीडिसीज ग्रैंड सन। Okay, I'll quickly just conclude that it might. Okay, it's okay. So number of decisions were given by Britishers, British judges, Indian judges, which has become the part of Muslim law. Muslim law, is it uniform? It is not. So Hanafi law, Shafi'i law, Maliki law, Hanbali law, Shia law, Khoja law, Kachi Memon law, it differs. So legal modernism rests upon the notion that the will of Allah was never expressed in terms so rigid or comprehensive as classical doctrine maintained, but it enunciates broad general principles which admit of varying interpretations and varying applications according to the circumstances. How do you interpret? What is the object of Islamic law? What is the object? What is the object of Islam? In my opinion, mercy or rahmah, compassion for weaker members of the society, fairness, good faith and justice. وَمَا أَرْسَلْنَاكَ إِلَّا رَحْمَةً لِلْعَالَمِينَ. Or as that in famous Qawwali, Aziz Mian would say, हमने चाहा था कि ताइफ पे क़यामत आए, पर ये महबूब की मर्जी थी कि रहमत आए. If rahma is the object, then any rule which causes injustice, which causes difficulty, and it is an interpretative rule, that rule is to be relooked. Islamic law or even Quran, as I said, it did not completely change the local customs of Arabs. Number of customs were modified. So dawar was there, meher दौरे जाहिलिया में भी था, प्री इस्लामिक अरबिया में भी था, but it was paid to the father of bride. So it was a bride price. बाप जो है वो अपनी बेटी का कीमत लेता था. इस्लाम ने उसे चेंज किया, रिफॉर्म किया, और उन्होंने कहा नो, दिस डावर, एज कुरान वुड से, पे डावर टू योर वाइफ्स एज फ्री गिफ्ट, as a mark of respect it is to be paid. You are starting a new relationship, start with a gift. Similarly, there was unlimited polygamy in pre-Islamic Arabia. Hindus in India till 1955 had unlimited polygamy. Till 1955, just 75 years ago, 70 years ago. Islam modified it, restricted it to 4, and then put a very, very stringent condition of doing justice and also telling you will not be able to do justice, therefore have one, and therefore better not. The real rule is better not. Then there were innovations made. Since wife was treated in the pre-Islamic Arabia as a chattel, and a husband can easily, at any time, at any moment, divorce, and the relationship was ending. So to protect women, Islam said you can't do that. Give a 3-month notice. And that's how the iddat period came in. Of course, it also determines the paternity. At a time in India today, where adultery has been legalized, it is going to be a huge problem how to determine paternity. I am surprised. I heard that the Uttarakhand draft says that iddat should be removed. If uniform civil code is going to include best provisions of all laws, I believe iddat provision should be implemented even on Hindus. For everybody, it is a good provision, because you would be able to determine the paternity of the child, and the husband will not have a right to give divorce straight away. Similarly, introduction of will. This was an Islamic innovation, and it initially said, bequeath equitably to your parents and to your relatives. The initial verse was this. Because prior to Islam, parents were not heirs. Prophet of Islam, being Prophet of mercy, gave a share to the parents. So a provision came in, make will in favor of your parents. By that time, that verse has not come, which fixed a share for parents. And therefore, the whole debate, whether it has been, abrogated or not, I'm not having time to go in that detail. But what I am trying to say, that there are differences of interpretation. Interpretation cannot be sacred. Text is sacred. Now, Quran, for instance, this was a verse in dispute in Shah Bano. Surah Baqarah ki chapter 2, verse 241, which said that make a fair provision for your divorced wives. Now, of course, it has been translated by some English translators of Quran as maintenance, which was quoted by Justice Chandrachud, and it created a lot of hue and cry in the country. But I am taking you to early Islam, how this same verse over time was differently interpreted, not by Chandrachud, but our own Qazis. So Ibn Jujara, Qazi of Egypt, from 688 to 702, considered this word mata as obligatory. Later Qazi Tawba ibn Namir opined that it was directed only to husband's conscience. And therefore, when he provided for this mata, in one case, the husband said, because it says like this, that there is a duty on you to make a fair provision for your divorced wives. Let's keep it there. I think I need to stop. And this word, mata, he interpreted as recommendatory, not obligatory. Because some translators said it is a duty on the righteous, muttaqi pe duty hai. So this second Qazi, when he passed this order, the husband said, Bhai, main muttaqi nahi hu. I am not righteous, and therefore this duty is not on me. And the Qazi accepted it. After few months, the same person appeared before him as a witness. And now Qazi said, I will not accept your evidence because you yourself said you are not righteous. And evidence of only righteous person is to be accepted. So there is a case for reform of Muslim law. There is a case for the diversity of laws. What is important is not the uniformity of law, but the justness of law. Legal pluralism is an established tradition. You can have number of laws. In America, you have 50 constitutions. Each state has different laws. So you may have 4 or 5 laws. If all laws are compatible with the constitution and are gender just, then there is no problem. I would say that we should go for small doses of reforms. We should have a piecemeal uniform civil code, ideally taking everybody on board. We should be able to convince our ulama because they control the pulpit of the mosque. Member unke paas hai. People follow them, not follow me. And therefore, What they did in 1939, that they borrowed the Maliki law. Why today they can't do this inter-school borrowing? I think the first stage of reform would be that at least to begin with, you borrow from other schools. That will solve 80% problem. Remaining 20% problem, look for a jurist. There are jurists who have interpreted things. Even for the drinking of wine, Hazrat Abu Bakr has put 40 lashes. Hazrat Umar said 80 lashes. So wherever there is an interpretation, interpretation has to be keeping in mind the context and the circumstances. We should ensure that the Constitution is the supreme law of land, and no law can survive if it is inconsistent with the Constitution. When Quran came in, earlier women were not, having any right to property. In fact, they were inherited as properties. Stepmothers were inherited by the sons and taken into marriage. Now, Quran talks of first category, or the Quranic heirs. Out of some 12 Quranic heirs, it mentions as many as 9 are women. It was a major revolution, a revolution of reform, a revolution of equality. Somewhere the patriarchy through clergy came in, and amongst the fuqaha there was debate. They were respectful for each other's views. Even Imam Yusuf and Imam Muhammad, both were disciples of Imam Abu Hanifa, and they used to differ. Our beloved Prophet is on record that differences in my community are a blessing. So we should make use of ijtihad. I think the Muslim Personal Law Board should not waste this opportunity. They must start the process of internal law reform. Thank you very much.